Good afternoon, everybody. Welcome back. Despite a long program and high temperatures, I see a full room, so very glad to see that. And I'm glad that we restart this afternoon with a session that on translating international legal opinion into right-based climate mobility policies. And for those of us who have worked in this space for a while, this panel could have been, for several years, we would have been speaking around the same topics, unfortunately, because progress was a bit slow. But the past 24, and particularly 12 months, has seen quite a lot of new developments. So it's an exciting panel for today, especially because we have the honor and the privilege of having as our keynote speaker a champion leader in this space, who came a long way also to be here with us, and we really appreciate. So I have the honor to invite His Excellency Hilda Heine, President of the Republic of the Marshall Islands, to address the audience today. Excellency. Thank you.
So I get to step up and you can actually see me. Excellencies, colleagues and friends, Yahweh again, and once again, warm Pacific greetings from the Republic of the Marshall Islands. It is a pleasure to provide the keynote address for this important session. Before turning to the substance of today's theme, it is important to anchor our discussion in the realities faced by those on the front lines. For Pacific peoples, climate change is an issue that touches upon profound issues of identity, livelihoods, culture, human security, and ultimately the continued presence of our peoples within their ancestral homelands. We therefore approach climate change not only as an environmental crisis, but as a matter of justice, rights, dignity, and shared international responsibility. For the Marshall Islands, the question of how sea level rise affects our maritime entitlements is already settled. Consistent with the 2021 Pacific Island Forum Leaders Declaration, the baselines and maritime zones we have established under the 1982 UNCLOS are not subject to erosion or reduction because of climate-driven sea level rise. UNCLOS imposes no obligation on states to continually adjust their baselines. Once a coastal state has defined and deposited its baselines with the UN Secretary General, those baselines and the maritime zones generated from them remain fixed unless the state itself decides to amend them. The 2021 Declaration, together with the 2023 Pacific Island Forum Leaders Declaration on the continuity of statehood and protection of persons, unequivocally affirms that Pacific states retain their statehood, sovereignty, and international rights irrespective of climate impacts. This position is firmly anchored in UNCLOS and in the fundamental principles of international law. Let me underscore this once more. There is no legal basis, nor should there ever be one, for the statehood, sovereignty, or maritime zones of the Marshall Islands to be diminished as a consequence of climate-induced sea level rise. Our government has been at the forefront of advancing this principle, and we will continue to do so. Clarity on this matter is essential. The recent ICJ advisory opinion and the work of the International Law Commission reinforce these long-standing principles, preserving sovereign rights over marine resources and enabling long-term planning for sustainable ocean economies. We must all support strong language in the forthcoming high-level political declaration on sea level rise, currently being negotiated in New York for adoption in September, that clearly affirms legal certainty and the protection of statehood and maritime zones. In terms of operationalizing these principles, I must emphasize that for the Marshall Islands, our people have been clear that migration is not an adaptation strategy to be forced upon us. Our National Adaptation Plan, launched in 2023, is carefully designed so we not only survive, but thrive on our islands as we have done for centuries. Adaptation in a remote Pacific atoll nation is not easy or cheap, however, which is why we rely strongly on international support to ensure the full funding of the plan's implementation. International law can be a powerful tool for creating right-based migration policies. I look forward to the discussion and to the ideas that will emerge from it. Komoltada, I thank you.
Thank you, Your Excellency, and I'm sorry I realized I addressed you as His Excellency. Obviously, I meant Her Excellency. Sorry about that. Without further ado, we have an excellent panel following Her Excellency's inspiring keynote speech. So I would invite our moderator, Professor Michelle Layton, who is the former head of IOM Labor Migration, among many, ILO's Labor Migration team, among many things. And Michelle, the floor is yours.
Is this on? Good? Oh, well, nice to see everyone in the room. Hope you had a nice lunch, and thank you very much. We have a terrific panel of experts, one of the best ever. These are my colleagues who are experts in their field, who I've, in many cases, worked with for many years. So it's a real delight and pleasure for me to welcome them to the stage and to have this discussion with you today. So first, let me ask Her Excellency Ambassador Anna Polak-Petric, Ambassador of the Republic of Slovenia. Please join us. And I would also like to now ask Walter Kalin, who is the envoy for the Platform on Disaster Displacement, and he's also a Robert Bosch Academy Fellow. I think many of you know him. He's an icon in the field. Thank you for joining us. Another advocate you may be familiar with, who I'd like to call up, is Mr. Andrew Harper. He's the Special Advisor to the High Commissioner for Refugees on Climate Action. He's been doing this in a very long time and notorious in his field for being a fighter for this issue. So thank you very much. I'll also call up Mr. Niccolo Delvino. He's the advisor for refugees and migrant rights for the Amnesty International and works here, well, works in Belgium, in Brussels, and quite an advocate for the human rights-centered focus for climate justice. So thank you very much for joining us. And finally, but certainly not least, I would like to ask Ms. Luisa Neubauer, lead organizer for Fridays for the Future of Germany. Thank you for joining us. So at the moment, I think most of you know that we are in, well, that many states are struggling to define multilateralism, to support multilateralism, and these are challenging times. However, the cases that have been handed down by the highest international courts in the international sphere and at the regional level have really been decisive on identifying and clarifying the obligations of states with relationship to climate change, but particularly with relationship to the obligations to protect those who are displaced, forced to move, vulnerable communities, whether they're women, children, indigenous peoples, disabled others. It's really amazing to see that the courts stood up and took a stand to really help governments understand what their obligations are when it comes to human rights in protection of peoples everywhere. And I think these are remarkable decisions to have come out in this era of questionable multilateralism, as some may call it, but certainly will have long-lasting impacts. And I think we're here today to discuss a few things about what these cases mean. First, we know that we have to understand how they clarify international legal obligations and what that means for stakeholders, whether governments or NGOs or municipalities and local communities. What does it mean for them to incorporate this and take it forward? Because decisions of courts don't implement themselves. And what does that have to do with adaptation? And the other is that while we know displacement is a regional and certainly international issue when people cross borders, it's also an internal issue when those who are internally displaced, and that is where most of the displacement happens, even though there is significant cross-border movements that are anticipated. But cities and local communities are on the front lines. We've heard this over and over again in this conference. Cities are on the front lines, local communities. How are they incorporating this? What does a case of an international court mean? And how can we help promote and advocate that as part of adaptation planning? So we will look at some of those issues in this panel, and I think with a view to seeing how this might inform the climate adaptation action agenda that the GCCM and this group has been considering, and including for small island states, relocation, issues of non-refoulement, and so on and so forth. So without further ado, I will begin our panel by asking the ambassador first. Ambassador, from the vantage of Slovenia, what does this emerging international legal discussion and these cases, the ICJ opinion, we have the Inter-American Court of Human Rights on climate emergency, we have the ITLOS, Law of the Sea decision, all of this happening very quickly. What does this emerging law mean for your country, for your work? And what does it mean in practice? And what opportunities do you see in the current situation for momentum around implementation?
Okay, well, first of all, thank you very much for this opportunity. I'm an international lawyer myself, so I'm following these developments, of course, with great passion, so to say. But first I would like to say I just came back from New York yesterday evening, and I had many discussions with a lot of state representatives there on other issues. But of course, the echo of these decisions, which you just, or the advisory opinions, let's be exact, right? Of course, they of course are there, and sort of the importance of these advisory opinions is clear to everyone, those who agree or those who don't agree, right? I would like to say that I also yesterday unfortunately missed the first day of the Berlin Climate Mobility Forum, which I believe brought here to Berlin so many high-level participants. I really congratulate organizers for this, and of course that shows how important this question is to everyone around the globe. If I'm a little bit critical to where I come from, I hope that next year we see also more European representatives in the opening of this great conference. Dear Michelle, I agree with you that you said there are actually two parallel trends which we see in today's sort of international relations, right? So on the one hand, we see worrying trends, where we see backslides when we speak about implementation or respect for international law. We see there are some major countries stepping out or leaving important international organizations and bodies dealing with environmental law. We also see that there is a lack of agreed legal commitments when we speak about the COP decisions and so on and so forth. So on that side, we are not satisfied, right? But then on the other hand, parallel to this, we see much more positive trends. And maybe to make some concrete examples of these positive trends, I will try to be brief because I know we don't have that much time, but you mentioned already, of course, two very important advisory opinions of the two international courts, so ITLOS in Hamburg and ICJ in The Hague. I also agree with you that these are the most significant, one of the most significant developments in international environmental law in the recent years. We can go into the details of what the opinions are asking or are sort of delivering or explaining to states, but I think I will just maybe draw attention to two. One is that states, of course, have binding obligations, so this was said very clear in the advisory opinion of the ICJ. And secondly, that these obligations not rise only from the climate treaties, which are not so many at the end of the day, or are very old, some, let's say, but that they come also from environmental law principles, they come from the customary international law, and they also come from human rights law and law of the sea, so UNCLOS Convention. So we should see this broader, what the obligations of states when we speak about climate change are. So I think this is very important. I would also say that parallel to the importance of the advisory opinion itself in The Hague is the process. I think what was very important is what an important role the small Pacific states had in this diplomatic struggle or diplomatic campaign, right? Me coming from Slovenia, which is also a small state, we are always so proud when small states win such important diplomatic battles, right? So really congratulations to this great initiative, which was done in New York and elsewhere in the world to bring us to the point of this advisory opinion. And the second point in this process is that almost 100 states participated in the deliberations of the court on this advisory opinion. So that shows how much interest there is around the world. And Slovenia, my country, also actively participated in these deliberations. And I think this shows, of course, also the importance of this opinion. On the practical consequences, of course, legal advisory opinions are not legally binding per se, this is clear, but they carry substantial legal and moral authority. And I believe that they will also have very practical consequences because they will bear significant weight in numerous individual lawsuits in national and regional courts around the world. They will be used in concrete human rights cases, as well as disputes regarding transboundary pollution, which of course will come in the future. Then maybe second, very positive development, which I would also like to mention, is the recognition of the right to clean, healthy, and sustainable environment as a human right. So this was supported in the General Assembly, UN General Assembly, by a gross majority of 161 states, no vote against. I think this is also a very important development. Slovenia was working on this recognition for, I think, more than 10 years. So we are very proud of this achievement. And of course, it means that we see, I think, that what's clear is that a majority of states in this world believe that no other human rights can be fully exercised or implemented if people do not have clean, healthy, and sustainable environment. And I think this is a very important development as well. Although the General Assembly resolutions, again, don't have a legally binding effect, it shows a very positive trend in the way how states think. And then the last point which I would like to make is the work of the International Law Commission, which was already mentioned by Honorable President Heine. So the International Law Commission has worked in the past on many important topics related to environmental protection, but recently, of course, very important on the legal effects of the sea level rise. And as was already mentioned by the President, I will not repeat, it is very important what the International Law Commission put forward to the states, that we need to preserve the legal stability, certainty, predictability, but also statehood, sovereign rights, and very important, to protect the human dignity of the people who are affected by this phenomena. So to conclude, let's say these first few minutes, I will say that still the field of international environmental law is still inadequate. The rules are still not developing as fast as maybe some of us would wish. But nevertheless, we need to recognize a very important progressive development, which shows that the area of international environmental law is one of the most urgent and topical areas of interstate cooperation, and that also that we see that the future regulation of this area will be focused on the responsibilities of states and international community in order to protect not states, but to protect individuals and their human dignity. So with this, I would conclude this first part. Thank you.
Thank you, Ambassador. That was quite a lot of information about the various cases and how that relates to states and their obligations and what this means moving forward. And I particularly was struck by how it's not just the legal decisions and legal obligations that were clarified, but there's moral authority coming from these decisions. And I'm glad you mentioned that the General Assembly has adopted by an overwhelming majority the findings of the International Court of Justice. That's not something that usually happens. There are states that contest it, but the fact that there was so much solidarity in these obligations means we're going to see a lot more of this, I think, as you said, in national court cases or simply influencing policies of government. So thank you very much. I'd like to turn now to Walter Kalin, because you have spent decades, I'll say decades, I won't say more, working at the, yes, decades, you're still young, working at the intersection of international law and the protection of people who are displaced. And of course, as many of you know, as many people know, you were the architect behind the Nansen agenda, for the Nansen Protection Agenda. And that, of course, was a landmark effort around protection of people in the context of displacement. So we're now, a couple of decades after that, seeing this case. How does the ICJ cases, the ICJ case and the other decisions affect state obligations in relation to disaster displacement in that context, but also for inclusion in climate adaptation planning? And I'd like, if you could, when you consider this, you know the Nansen experience, of course, in the political context, used a strategy of cross-regional coalition building. Is that still relevant now? Is that something we should use as strategy now to promote these legal obligations? Or is there something different needed? So thank you very much.
Thank you very much. How does the ICJ and other cases help clarify state obligations? You shouldn't ask this question to a professor of international law, because he will talk non-stop for 45 minutes. But I try to be short. First, of course, as was already mentioned, the ICJ has endorsed the principle which was developed by the UN Human Rights Committee, the expert body monitoring the implementation of the Covenant on Civil and Political Rights. The ICJ has endorsed the principle that people from states affected by climate change cannot be deported, cannot be sent back to those countries if there they would encounter life-threatening risks. So it has recognized the applicability of a human rights-based principle of non-refoulement, not refugee law, human rights law, that it applies to disaster and climate change contexts. Some of us would have hoped that the court would go one step further and say, well, people cannot be sent back under certain circumstances, but what then? And that's the question that the Inter-American Court of Human Rights did address, namely the positive obligations of states. It said states are obliged to enact legal provisions and mechanisms, and I quote, to guarantee the legal and humanitarian protection of persons displaced across international borders due to the impacts of climate change. So states, yes, have to act. Legal provisions, mechanisms to protect them. But then again, I'm not so happy because they limited this to persons displaced across international borders. And as you said, most people are internally displaced. And I think this obligation to enact laws and institutions and processes, this was something that was picked up by a national court, namely the Constitutional Court of Colombia in 2024. And invoking not just Colombian law, but also international law, the Constitutional Court came to the conclusion, yes, the state has to provide legal protection also for people displaced in the context of disasters and adverse effects of climate change. And then on adaptation, another important decision, 2019 by the UN Human Rights Committee again, Billy versus Australia. The decision was that the right to life may oblige states under certain circumstances to invest in disaster risk reduction and climate change adaptation if otherwise people would have to move in order to save their lives. It was about the failure of Australian authorities to repair and to build new seawalls on a low-lying small island where an indigenous community was living. Coming back to the ICJ, what is potentially really very important, and I say potentially because the court didn't say it directly. The court said that under certain circumstances, emitters, the main emitters, if they are violating their obligations under climate law and other conventions, are becoming internationally liable to pay compensation. And if you apply it to people who already have been displaced and experience loss and damage, I think this may open up new avenues, a new framing for discussions on loss and damage financing. But it's a political issue. So overall, yes, important steps. But we're still far away from a coherent set of jurisprudence that would comprehensively determine the duties of states. These advisory opinions, some of the decisions set out very general principles. In a way, I think the ball is now in the court of the domestic courts, the national courts. We will have a lot of strategic litigation coming up invoking these advisory opinions. And we will have some cases that people will win. And I think this then, not immediately, not this year, not next year, but let's take a 5 to 10 year horizon, will feed back into political discussions, legal discussions, and in that sense, there is a potential that these advisory opinions are really a game changer. Coming to your second question, we worked at the Nansen Initiative at the time when multilateralism was still functioning relatively well. But at that time, this was back 2012, states declined to discuss the issue of climate-related human mobility displacement within the UN. And there was a few states that took the initiative to take it out of the UN, to start to do consultations, including in the Pacific, the first one on Cook Islands. You were also there from Marshall Islands represented, where we came up with messages. The idea was to frame messages and then to feed them into processes. It worked relatively well. Our states managed to get human mobility into the Sendai disaster risk reduction framework. 1 year later, 109 states endorsed our protection agenda and then directly went to Paris, where the task force on displacement was created. Together with many others, we managed to firmly anchor the issue in the Global Compact on migration. Yes, it worked. Coalitions of the willing cross cross-regional cooperation. But today, of course, it's different. Multilateralism in deep crisis. But I think it only means that regional processes, cross-regional coalitions of the willing, that's becoming even more important than ever. But ultimately, this then has to be linked to the formal processes. Otherwise, it will be somewhere floating up to this desk. Thank you to this roof up there. Thank you very much.
Thank you very much, Walter. And yes, a coalition of the willing. The hope is that we see there may be the beginnings of a coalition of the willing who have been participating in this set of workshops over the last 2 days. So hopefully they will continue that path. But I think it's also true that it's going to depend on national implementation and regional discussion. But I think you've stated very clearly the foundation is there now, and the cases like the decisions like the Inter-American Court of Human Rights really set out details with which I think policy planning can also be can also include those obligations and anticipate. So now I'd like to turn to Andrew Harper. The argument that states cannot return someone to a disaster, conditions of acute disaster or severe climate-related degradation is beginning to take hold, either from these opinions, but certainly from other judges, other courts. It's becoming more recognized that these conditions are significant, and I think Walter mentioned the right to life has also been discussed by the court. So it would be interesting to hear how UNHCR is responding to this evolution. You're ahead of the game, I think, in any case well, maybe not, okay, well. You're out front. Let's say you're out front. You're out front trying to help states and other actors deal with this. What are the opportunities that you see emerging in the wake of these recent legal decisions? And I say that cautiously because Andrew is often in the field dealing directly with people on the ground rather than with international lawyers. But give us your perspective.
Okay. On this topic, I feel like a fraud, particularly more than a fraud than I normally am, because I am very much in terms of what is the impact. And we can go through a lot in terms of the recent decisions, but after following Her Excellency and Walter, I don't necessarily need to go through too much. But I think if anything, like just being a layperson, that it gives us confidence that we're not just losing all the time. I think in this world where our funding is being cut by 50%, from UNHCR's perspective, the numbers of staff in the field has been cut from something like 20,000 to 11,000. Our colleagues in the World Food Programme have had to cut 50% of their food rations. And it goes on and on. And so USAID has been dissolved. And so it's not just like protection agencies that have been hit, it's everyone. And so if you're actually displaced or if you're on the front lines of climate change, who do you go out to and seek some degree of confidence that someone is listening to you? It's not really from the UN at the moment. It's not from UN agencies or other governments, because just as the US is cutting back, so are others in terms of support. And I think if anything, when you see the ICJ advisory opinions, or when you see the Inter-American Court of Human Rights, you think, thank God. Thank God there's still something which is positive out there, which gives us a chance to keep moving forward. And so we should not underestimate that. And as Walter was mentioning as well, it's not just the decisions, it also gives the confidence for domestic jurisprudence to youth, to others, to say, look, there should be accountability. And I think one of the key issues is what UNHCR is trying to do. And it's good that you think we're being so positive, because it's really challenging, is that we have to try and figure out, okay, even though the winds are going against us on so many fronts, at a certain point, unfortunately, the situation is going to get so bad that there has to be more engagement on adaptation. There has to be more investment in loss and damage. And all we can do, because the bottom line whenever I talk about why we're concerned about refugees, is that climate change is impacting everyone. It's like we're in here and it's pretty warm, but it depends on who you are and where you are. And it's not equal. If you're in a small island developing states, it's one thing. If you're in the Sahel, it's another thing. If you're a refugee and you're under plastic sheeting with no documentation, no right to work and no right to move, you've got a hell of a way to try and adapt. So and this is one of the reasons what people sort of say, why is UNHCR involved in climate? It's because we try and struggle to find anyone who's more desperate than a refugee who's crossed the border from Somalia into Kenya. Or could be anywhere else. Sudanese going into South Sudan. Elsewhere and elsewhere. So what we try and do out of all these is to see, okay, how do we use these advisory opinions or these decisions or basically, again, the goodwill of the host states to include refugees in their national adaptation plans, in their development plans. But quite rightly, host states are saying, okay, like your funding to us being cut by 50%. We're getting more and more refugees. You're saying that you've got a solution or a vision which involves us doing more work and giving us less resources. How does that play out? So what we're trying to do is to use these decisions in order to encourage multilateral development banks, the Green Climate Fund, the Adaptation Fund, to say, look, stop focusing on where it's easy to work and focus on where the needs are. Focus on vulnerability. Focus on people rather than profits. Try and look at de-risking. And what is going to be also interesting, when we're pushing them, and they're slow, they're scared, they're talking to their board members, but we're talking to their board members and saying, look at these decisions. You do have a degree of accountability. But then I think the next step is to start having the private sector to come in here and say, okay, you've also got accountabilities. You may not realise it now, but courts might be recognising that in the years to come. So get off the fence and start being more active in these areas. I know I probably didn't answer your question, but we've got enough lawyers who can answer the questions. But I take it out as a very positive means, and something which is not just something which can be turned over tomorrow. But at the same time, if I'm leaving on one point, refugees are not migrants. Refugees do not have a choice. And we fought bloody hard over the last 10 years or so to make sure that refugees and displaced persons are in these texts. And the reason for that is that they do not have the protection of their state. And we've got to protect that. Thank you.
Thank you very much, Andrew, for that, bringing us back down to the ground. But it's interesting that you have identified that UNHCR can really use these decisions as a bit of wind under the wings and to push the private sector, to push governments to try and do more, the IFIs, the financial institutions, to step up now that they can see the writing on the wall, that there are these obligations, trying to push them in the direction of doing the right thing even before court cases have to be brought and so on and so forth, which can be lengthy. So thank you for bringing us back to the ground and to the reality of what these mean. I'm now going to turn to Nicola Delvino, and I know what you're going to tell us about will be mostly focused on the Inter-American Court of Human Rights, because as a human rights lawyer, an expert, this is probably the most meaty decision to come out about climate obligations, complementing the ICJ decision. So building out from there a lot of the accountability for governments. So can you tell us what are the most critical obligations that you can see from these decisions, and I know you'll focus on the Inter-American Court, and state actions, and do they tell us anything about what advocacy strategies we would need to ensure that we can have these implemented? So your thoughts on this?
Hello, everyone. Thank you very much for the question. It's an honor to be speaking in this forum with this distinguished guest. with the little problem that the presentations were so comprehensive and excellent that many of the points that I wanted to raise will be a bit of a repetition, so I apologize for that. But I really welcome the questions on what are the main human rights obligations that come up from the advisory opinions. And obviously, as the ambassador has remarked, the applicability of human rights law to climate justice is one very key aspect of both the advisory opinions, the ICJ and the Inter-American Court of Human Rights, the reiteration of the importance of the right to a clean, healthy and sustainable environment as the preconditions for a number of human rights that are impacted by an unhealthy environment and climate. And in particular, the Inter-American Court of Human Rights speaks specifically not only of a right to a healthy environment, but the right to a healthy climate. And that is a preconditions for having respect for the right to food, to water, to an adequate standard of living, to life, to health, to family, to basic conditions of life for the people that are impacted the most. And I would also highlight a new point, and that is that there is a clear indications as fossil fuels being the culprits of a human rights crisis, and that there's obligations for states to tackle that. And Amnesty International has been calling for quite some time now for a full, urgent and funded transition away from fossil fuels, and because we've spoken in these days quite a lot of the right to stay, these are the preconditions for people to continue being able to live a life with dignity where they want to live, if they want to stay. But if you'd allow me, I would also talk a bit more of the right to leave. There is not such a right per se, but there are important indications in the advisory opinions for people possibilities to migrate. And that's not because that should be the priority, but that's because I want to show that the advisory opinions show that migration, mobility should not be a mutually exclusive dichotomy with the right to stay for those who want to stay. And there's two aspects. There's obviously, as the speakers preceding me have noted, the right not to be returned to a country where people would be at risk of human rights harm in the context of climate change under the non-refoulement principle. This is not new in the sense that, as already noted, the UN Human Rights Committee in the Teixeira case had already clarified that, but now it's also the Inter-American Court of Human Rights, it is the ICJ, and I have to say it's domestic courts as well that are recognizing this. And that's a point where I will get back again on in a second. And then, as it was also noted, not only the obligation not to return people who are already displaced, but the Inter-American Court of Human Rights is going to step further in saying that there should also be an obligation for states to establish appropriate migration categories. So for people that are not displaced yet. What does it mean? The Inter-American Court mentions temporary visas, humanitarian visas, temporary residence permits, or international protection categories, recognizing also the different needs that people might need, because there's people that might need to relocate only temporarily, and there's people who will need a permanent residence permit because they cannot go back. So it is important that when we talk about the right to stay or the right to live and climate mobility, that these two need to come together, that there will be some people that will need migration opportunities across borders. And so, for example, for sea level rise, the court, the ICJ has also noticed that sea level rise is unavoidable. So there will be some impacts, and some I wouldn't say communities in total, but some people within the community as more vulnerable will also need to have access to migration opportunities. And fortunately, this doesn't happen in a vacuum because there are examples, some examples at national level, and there's also the Pacific Regional Framework of Climate Mobility that recognize the role of rights-based migration opportunities to respond to the needs of climate migration, climate mobility. The ICJ did not go as far as the Inter-American Court, but it did say that the states have a legal obligation to cooperate in any issues of economic, social, cultural issues. What does that mean? It mentioned the obligation to cooperate in many parts of the advisory opinion, but also in the part related to sea level rise, which is also where the ICJ then talks about later on non-refoulement obligation. In our view, is that one way to cooperate is also for states to come into bilateral or regional frameworks, such as the Pacific Regional Framework for Climate Mobility, to also consider safe mobility pathways, including migration pathways. And I'm very happy to see in the global principles that have been presented these days that there's the priority is the right to stay, but also as number 2 principle, the possibility to consider safe mobility pathways. And going to the next part of the question as to what we can do, what does it say in terms of advocacy? Well, these are exceptional advocacy tools. We've heard that the ICJ advisory opinion is non-binding, but let's not fall in the trap to think that the standards that they interpret, they are not binding, because they interpret international obligations. And this is the most authoritative interpretation of legal obligations. So when you do advocacy for the international legal standards that are in the opinion, don't treat them as non-binding. They are absolutely binding and enforceable, and so they should be treated. And the ICJ just gives a better interpretation of them, the best interpretation that we could have at the moment, and same for the Inter-American Court of Human Rights. And the other important thing is that it does not create new legal frameworks. Like we've been stuck for ages talking about, do we need a new refugee convention on climate displacement? Do we not? Like, you know, it's been a dialogue for a long time. The court says that we don't need it, that the standards are there. It's just an issue about how we interpret, how we implement them. So how do we move forward from there? Well, first of all, I think that these important litigation initiatives that were taken were just the start. We've heard from the other speakers that it's the moment for domestic courts to apply the standards that were interpreted in the advisory opinion. So it is the moment for strategic litigation at national level. It is the moment to raise awareness of the content of the advisory opinions with legal operators at national levels, with lawyers at national level. And when I say this, I mean both strategic litigation in the climate space, but also strategic litigation in the immigration space. And it is very important that, for example, immigration lawyers, I'm an immigration lawyer at basic, and when I speak with other immigration lawyers, many times they don't know what are the standards that apply to people in the context of climate change. They will say, oh, climate change does not apply to refugee cases or other cases. Actually, what we know now is that it does apply the non-refoulement principle, and we need to make sure that lawyers know that. And obviously, we need to expand advocacy at national level for the norm internalization of the things that the advisory opinion says. So, for example, this is not, again, happening in a vacuum. There are national practices providing humanitarian visas. The Nansen Initiative identified many of them. There's the Pacific Regional Framework on Climate Mobility that mentions the rights-based migration opportunities. The Australia Tuvalu Falepili Union, even though technically it's not a dedicated climate visa, it happens within the space of climate change negotiations and conversations. And it is, in our view, respectful of certain human rights conditions, that it does not discriminate, for example, against people with disabilities or for age and so forth. It is important that when we do that, when we do the advocacy or the strategic litigation, we link issues of climate justice with issues of migration. And then when we talk about the right to stay, we should not talk it in a way that denies the migration from the aspect. Obviously, climate mobility is not only about migration. It is absolutely not. But migration is part of it and needs to be considered. Otherwise, we risk that we just deny the agency that is not there if there's no migration opportunities because migration policies are too restrictive. And I will just say one last word. We talked about the rule-based order. Defending the rule of law, probably in every aspect where we see it threatened at the moment, is the best way to ensure that advisory opinions are followed through. And there's more to say about this, but I'm aware that I'm talking for too long.
No, thank you so much for that, Nicola. Really insightful. And the time is to act now. This is what I take away, to act now at the national level, not just litigation, but advocacy, and use these as tools. So you've just outlined a very rich array of how groups can take these into their own work. So thank you for that. Now I'd like to turn to Louisa Neubauer and ask a bit of a provocative question. The climate movement has always understood, I don't know if you agree with this, but hopefully, that waiting for the most powerful states to act is not a strategy. That we have to take action into our own hands. So the multilateral system is under strain, it's challenged, and that means that it's up to national groups or international groups, actors, stakeholders who really are, as maybe Walter had said, a coalition of the willing to try and move forward. So a question for you is, as you look at building a coalition of the willing across governments, cities, civil society, and communities, what can we do to make it powerful enough, or would it be powerful enough to protect people? And what responsibility do citizens have as reluctant, perhaps, actors in this kind of coalition?
Thank you. Excellent question. Well, maybe starting from the legal side of things, I've been part of a climate litigation case here in Germany. We brought the climate crisis to a constitutional court, and we won, at least partly won, that case that humbly carries my surname. But we hear, yeah, well, it's nice, you know, you get to sue your own government. You do it if you get. But we try to not name it, you know, the Neubauer versus Germany case. We call it the climate litigation case, to make sure this is not about climate activists against government. This is about people's rights to exist, and for especially younger generations, a right to a future. Because what we brought to our constitutional court case was the idea that every generation should be able to enjoy the same amount of freedom. They call it intertemporal right to freedom. Probably many people in the room know this. And now, ever since we won at least parts of that case, people ask me, oh, with the climate movement, that's all great what you're doing, but eventually, are we going to win the climate crisis at the court? Is this going to be the place? And especially in light of some of the amazing developments that we've seen in the past, I would very much warn to take this perspective, because what we've learned from our case in Germany, and I think what we've can witness with the ICJ cases, with many, many other cases, what made those cases possible in the first sense wasn't just legal knowledge and qualified lawyers, as much as we need them, but it was people shaping and shaking norms. We were able to win those cases because we changed something. 10 years ago, we would have lost, because the court would have said, probably, what is a climate crisis? Now we knew there were lawyers in those courts sitting with their children back home saying, Mom, Dad, what are you doing to protect my future? So I think number one, when we talk about the doing, what does it need? I think it needs the understanding how interlinked those ambitions are. It's not enough to fight for those court cases alone, and we've been seeing and we're witnessing right now how empty even some of the strongest litigation cases can be if there is no follow-up, if there is no lobby to say we're going to fight this through, not just to get any case to a court, not to get any ruling, but for then to see some part, like some extent at least of implementation. And I'm worried that at least in the public eyes, these court cases are considered to be a shortcut, but there is no shortcut. There is this long road we have to take, and we need to be smart in it, and we need to, build those broad alliances. But just having a court ruling won't change anything. It is then up to people, alliances, countries, if you've mentioned the national the courts and states, to implement those very rulings. And the second point, maybe what was most powerful, I find, about the work that we did here in Germany, Europe, and beyond as a climate movement. We came out and we talked about unite behind the science, and we thought, the facts is the most important thing. When we went to the Constitutional Court, we sent them all the facts in the world. We were like, just read the facts. We got the science on our side. Eventually, though, what was probably most powerful wasn't the facts, but the emotions, the stories, and the narratives that we brought out to a public, making sure that they live in spaces where we wouldn't ever enter, making sure that in any room, any CEO boardroom or any political party or any whatever convention, there would be someone, passing forward those narratives without any climate activists to having to be in the room. And when we speak about these legal questions of migration, of a right to stay and a right to move, as you so brilliantly put it, I find what we heard earlier in your keynote about not just surviving but thriving to be quite a key element, because we do talk about these technical questions of being able to move and to leave, and of the rule of laws and what they can do, but eventually this is about creating a justice that can protect dignity and that can create a way of existing on this planet that we haven't seen so far, that is not about exploitation, that is not about just delivering to the most powerful, but to respect any kind of existence, human and non-human existence. So with all these, I find all these very brilliant remarks we heard, I find the underlying question is, why are we doing this? And what is the very easy translation that can move beyond those technical questions, these technical legal questions? And finally, maybe just to you mentioned that right at the end of your remarks. We've put so much effort, and so many of those powerful institutions put so much effort into strengthening the rule of law, into making sure that human rights and climate justice are moving forward together. And the most powerful people in the world have tried everything to make sure that while we are pushing towards educating the rule of law, they have tried everything to delegitimize the rule of law. That is what we've been seeing in the past years. You have been very nice to Europe when you said that, European countries are not showing up. They're not showing up at all. We are failing to stick to our climate targets. We're betraying a vast part of the world that we've been robbing from in the past. We're letting the people that have to leave their home drown in the Mediterranean Sea, and then we're cutting funds on climate science. That is what a continent does that understands itself to be a cradle of human rights. Not even speaking of other parts of the countries that are failing, of the world, that are failing even more. Everyone talks about climate justice. We get these brilliant court cases, and then we see fossil fuels rising, and inequality globally on its peak. So I find it's important and crucial to be honest. You've made some of those points. To be honest about where we are, and that it's not just enough to bring forward new cases, but to create conditions under which those cases can actually come into reality and change the world we live in.
Thank you so much, Luisa. I think you've really explained passionately what we need to do next, and certainly not sit on the laurels of cases, but really take things into our own hands and keep moving forward. But yes, we are nowhere near the end of this fight. It is really a beginning point. So thank you so much. I'm actually cognizant of the time, I was given another question, which we may or may not be able to ask our panelists, because I want to open up the floor to your questions. I know there may be some of them, although you might be asleep from this heat with, I see some fans going. Probably not enough fans. But having said that, and knowing our time limit, should we take a few questions to the panelists or comments, and then we can see what time we have left for concluding. Does that sound like a good way forward? I see some nodding, not so much. Okay, so please, if you have questions on the topic, you have comments, or you reflections, let us know and they'll bring the microphone to you. Who are the first brave souls?
Hi.
Okay, Shayna.
I'm happy to kick off with a question. Hi, everybody. Shayna Tabak.
From the organization, tell us what organization.
Sure, Carnegie Endowment for International Peace, where I lead our work on climate and mobility and do a lot of thinking and writing on the topics that you wise people are speaking about. So I think I echo some of the frustrations that our last panelists talked about, and have really been noticing this gap between, so I am a lawyer, but I've shifted somewhat into the policy space because I'm recognizing this sort of gap between what we see in the legal space and these wonderful decisions and the policy outcomes. And I think one that a lot of advocates talked about last year was the recognition that we had this amazing decision, very unexpected, from the ICJ in July of last year. And then we all went to COP, and we didn't have an amazing decision from COP. And I've been thinking about, why is that? What happened? I've noticed, in some governments, there's a lack of capacity, and the folks who went to the ICJ didn't necessarily go to negotiate at COP. So maybe there was a gap there. Obviously, there were a lot of changes and tumult in the international systems. But I do feel like these are slow-moving processes. And so I guess I wonder how you all see some of the opportunities that concretely do exist, in addition to bringing cases, but I'm actually more interested in some of the sort of outside of the multilateral system opportunities for driving policy that we might be able to take inspiration from these cases, but then can really drive things in the policy sphere.
Great, thank you. Should we take another one or two questions and then ask the panel to answer? I don't see any other hands, so I think we start with colleagues on the panel. Who would like to respond? Anyone taking the bait?
Well, I can start, and I think it's an excellent question. And I don't have kind of a full-fledged answer. But what I'm right now presently quite a lot of thinking about is how can we bring the issue to other fora? When we're talking about human mobility traditionally, like internal displacement in the context of climate change disaster, it always has been looked at as a humanitarian issue. And then UNHCR was called in and other humanitarians. And that's in a way very narrow. Then we have, again, other silos. And it's about loss and damage, and the loss and damage fund doesn't have sufficient money. And even if there is money, communities cannot access it because it's too complicated. So and I don't have the solution, it's just kind of the way of thinking. I think we have to think much more about how to mainstream these issues. If, for instance, and again, I'm looking at internal displacement. If, for instance, all those working on food security would say, okay, we have people here that have been displaced, they can't go back, they are food insecure. Why should we continue to just hand out food, but rather integrate solutions for those IDPs into these kind of projects? And I could add, I had a very good discussion this morning with a colleague who is now also a fellow here from Kenya about the transformation of the pastoralist sector in light of recurrent droughts, etc. But again, that's a discussion that has nothing to do with the 1 million IDPs who were pastoralists, who have lost all their animals, sitting at the outskirts of Mogadishu. So let's build those linkages. It might also help to some extent depoliticize some of the very politicized discussion we have right now. But as I say, it's not a solution, it's just one of the perspectives. So,
I think there's just too much focus on COP. I don't go to COP with any expectations whatsoever. And obviously I come from a refugee background, so the issue is that we want immediate action. Host governments want immediate action. Small island developing states want immediate action. And you go into a process which talks in 5-year, 10-year timeframes. So there's a disconnect there. So what we'd be looking at is where are there other opportunities? Again, this coalition, the willing, if you try and look at the UN or the COP or to get a consensus, then you're not going to get action. Let's be serious. So look at, for instance, the small island developing states, then bring it back down, look at South Pacific. Is there achievements that we can reinforce based on their leadership? The IGAD region, Article 16, I think, freedom of movement. Try and figure out where are there opportunities, not where there's barriers, because there's too many barriers. And then I think there's a lot of communities and states who just want to have confidence. So I'm focusing a lot on Syria at the moment because I think there's opportunities in Syria. Trying to get the Green Climate Fund to be more, let's say, I don't know, effective. Same with the loss and damage, fund for loss and damage. They're not effective at the moment because they take too long and too much money gets stuck in capitals. Because there's some estimates that like 10% only actually gets to the communities. We need to have better data, more data about actual impact on the ground, and the communities need to be taking the leadership. Something which, in terms of, for instance, the South Pacific Islands, prior to pre-COP, can we get a better idea of what the priorities are to actually implement these principles or declarations or whatever? So we need to have a roadmap beyond talking and signing documents. Thanks.
Do we take another question or do we answer?
Please answer because then we have another question. But first, why don't you answer?
No, but I think then these were excellent answers, I find, right? Yeah, I would add just try and error. Try out a trillion things. We all have to. And we find something that works. Yeah. But let's, right, should we oh no.
Maybe just very quickly to go back to the point of what can we do outside of the normal processes. That's I think it touches on what I wanted to say at the end about the rule of law. And that is that this shouldn't be treated as an issue of climate. It shouldn't be treated as an issue of migration. It should be treated as an issue of justice. In the sense that we have seen, in the space of migration for years now, that the rule of law is just not respected. And many other fields of policy making, they were just not caring about it because it started from there and then it will stay there. Now we see it in every aspect of policy making. So it's just an encouragement for all of us to open our eyes that if it happens in a field of interest that is not yours, it will happen to your field of interest as well. So let's keep the eyes open and fighting authoritarian practices and contempt for the rule of law.
Thank you, colleagues. I do see some other hands up, so please, we'll take your question, and then Caroline, I think you had a question. I haven't seen it.
Thank you. Very, very useful conversation. I'm Harjeet Singh from Satat Sampada Climate Foundation, and I've been working in the field of adaptation and loss and damage, particularly with the Loss and Damage Fund. I find, like you said, Andrew, that we have much more expectations from the COP. I see the same thing happening with the private sector, and conversations keep coming up in the field of adaptation and now also on loss and damage, where the reality has been that if you look at the funding that's flowing to adaptation, it's barely 2% coming from the private sector. That's where we are. And I also see that we have not really laid out what we expect from private sector and where the challenges are. So in my view, first of all, we should look at the private sector should not cause any harm. So it's the do no harm approach, and for me, that's the biggest one. Then they have a huge role to play to climate-proof their own supply chain, which I think is extremely important, and they are not doing it enough, both in the developed and developing countries. If they do that the entire supply chain, and I'm talking about global supply chains, that's going to help communities a lot. And of course, extending that to then workers and communities and their families and their village, again, which is where the direct connect is. And then sharing expertise and resources beyond their businesses, and they do bring in that technical expertise, and doing philanthropic work. Where I get really worried when we start looking at the role of private sector, and particularly multinational companies, in making profits from adaptation and even now loss and damage. I don't know how, because when we talk about retrofitting homes, building dikes, early warning systems, raising plinth of their houses, or climate resilient seeds, these are all public funded activities, these are all public goods. So if we involve private sector there, I think then we are not really adopting the human rights based approach. So we need to be careful about when we keep saying a blanket statement of involving private sector, be very specific. And we don't enough talk about taxing windfall profits that they are making as we speak. You talked about Nicola, you talked about fossil fuel industry, and we are not taxing them enough. And my last point, when we say private sector, we always think of large multinational companies. Whereas in both developed and most developing countries, we find that it's the micro, small, and medium enterprises that are running the economy and providing jobs, and they're also quite vulnerable. We should also see them as private sector and make sure that the resources flow to them and make them resilient, and their contribution is going to be far more than looking at just multinational companies. Thank you.
Thank you for that, and for raising the issues of the private sector and small and medium enterprises who are also going to be affected by climate severely in many cases. So Caroline, you have a microphone? And this may have to be our last question because I'm looking at the time. Andrea, he says yes. We'll have the panel answer, and I'll ask the panel to answer the last question, or comment on these last two. And maybe you can throw in something about, is there anything that makes you hopeful or not hopeful? Thanks.
Thank you so much for this panel. My name is Caroline Popp. I work for the Expert Council on Integration and Migration here in Berlin. And I've been involved in climate and migration work for many years. The title of the panel is obviously Climate Mobility Policies, but the first principle of the principles that are being presented at this conference is right to stay. And I find that quite remarkable that this is not just in the principles, but for many years in the very mobility-minded community that is working on this issue, the right to stay, the sort of sedentary bias is so strong. So maybe just as a remark, but I also know that the term "the right to stay" makes some lawyers nervous, but I personally think it's a very powerful tool to articulate and to focus exactly on this mainstreaming approach that Walter Kalin mentioned, to focus on resilience and adaptation and mitigation first, and mobility as sort of a secondary category to that. But I'm curious on what else you would do to articulate the right to stay both legally, but also as a sort of policy, public message, maybe in terms of the intergenerational justice that you mentioned, and especially in a context where here in Europe, it does unfortunately also play into the sort of keep them away attitude when it comes to migration. Thank you.
Thank you. Who would like to go first?
I love your remarks and questions. Maybe to just bring a positive example here, or introduce a positive example. I would say in the climate discourse in Germany, we don't even speak of the right to stay only, but of the freedom to stay. So the Bleibefreiheit, which has been a term more used, which is, I find, a beautiful approach to the questions that we have. And it's really, it's accompanied by this idea of the late Bruno Latour, who said there's two types of migration. There is the people leaving the land, But in the 21st century, there's another kind of migration, which is the land leaving the people. And especially the latter is one where I find a lot of people around the world, whether they're on the front lines or not, can resonate. It feels to many, and I would say especially younger people, that the land is leaving us. This is our home, but what is this place? And why do we feel like a guest in a world that should be our own, right? And so I find here there is a huge potential to start where people are right now, emotionally, politically, socially, to pick up on those worries, bring them into the legal field, but also back, and make sure we create frameworks that aren't just, foreign words and languages that people don't understand, but resonate with a shared reality around the world. In particular, then bridging this idea of migration being a threat, but also being misused a threat from especially far-right politics, and turning this around as a shared vision of what it means to live.
So I guess we have to be really quick now. I'm looking at the time. So please, everyone,
It's not
just
my best
some short perspective.
It's not my best quality, but I will try to be quick. I absolutely agree with you in the fact that talking about the right to stay has some very positive connotations when it's meant as nobody should be forced to do something. But it also has a connotation that can be exploited in very xenophobic contexts. Nobody has the right to stay. I mean, everybody has the right to stay. Nobody has the right to leave. You have the right to stay, so you have to stay. And actually, what that conversation misses is that when we talk about agency, that should include the obvious prerogative of a person to stay in the place where they want to be and live and where their home is that it denies that there's no agency when the person also doesn't have any possibility to leave. In the context of today's migration policies that are very restrictive, people cannot just decide to stay or leave. In most cases, they are just forced to stay. So I think it is very important of the right of a person not to be forced to leave their home, but not as to staying and in denying them the possibility to leave if they want to do. And our experiences when you talk to people is that people want to have that opportunity. It doesn't mean that they will migrate. We've spoken with many people in Tuvalu after the Falepili Union Treaty was adopted, and many of them, they were applying, but they were applying not to leave. They were applying to have that opportunity in case disaster happens. So they wanted to have the opportunity to migrate to Australia, but not to migrate to Australia, to stay. So I think that when you actually give people agency, then they have the possibility to decide what's best for their life on staying or leaving. But thank you for raising the point.
I come from a refugee agency, so I think that the issue is let's get people stop fighting to begin with. The issue of peace and security, critical. So we're focusing on climate, but climate is not necessarily the reason why people are being forced to move in many situations. It's an underlying factor which exacerbates poor governance, poor water management, poor conservation, environmental degradation, poor education. So we often sort of see climate as the catch-all. It's not. It gives a way out to many governments not to do anything. So so I'd say, look, people want to stay. Everyone wants to stay with their own communities if they can. So yeah, there's no money for food, for education and healthcare or climate, but there's a hell of a lot of money going to fighting Iran or to providing weapons to Sudan or to nuclear. It's just disgusting. There is just people who say there's not enough money for adaptation are just basically identifying that there's no prioritization for adaptation. And again, going back to the issue in terms of the private sector, it is profits before people. And so we do have to go out and call them out. How much is Germany? Well, I don't want to sort of knock Germany. Okay. No, go away.
Keep going.
No, but our operations around the world, so 70% of the world's refugees are located in countries with the least capacity to adapt. And many of the representatives are here. And our funding is being cut by almost everyone in the EU. Is that better? Everyone in the EU, because money's going to Ukraine. Fair enough. But not everything is equal.
Is that your positive note, Andrew?
I'm positive because I'm allowed to talk. It's not positive for you, I'm sorry.
Oh, yeah.
On the right, to stay at the Platform on Disaster Displacement, already in the Nansen Initiative, we are promoting a toolbox approach. When are people forced to move? When they are exposed to a hazard and too vulnerable to withstand the impacts. So what we need to do is to try to reduce the hazard, that's mitigation. We have tried to reduce the vulnerability, that's climate change adaptation, that's disaster risk reduction, that's development in the sense of the SDGs. And we have to try to reduce, to work on reducing exposure. That's planned relocation, that's migration pathways, migration dignity, safety. And only if all of this fails and people are still displaced, we need to protect them. So we need all these tools. Hope, the fact that it's so hot here. Because yes, Europe is getting hotter, and I think people start to understand that climate change is a reality and that we have to get out of an economy that is based on fossil fuels.
I will just have one few words because we're already over time, and I will actually answer more to your question when you said if we're positive, if we're optimistic, and so on. And of course, we are aware of all the shortcomings. I'm aware of all the frustrations because things are not moving as fast as we want them to move. Of course, we see lack of implementation, so this is quite clear. But nevertheless, I'm optimistic because if you look at the developments in the environmental law protection, they are steadily progressing, and this is important. So if you look at the world before the Second World War, there were no human rights conventions. People thought that a state can do whatever they want to its citizens, and look at where we are now. 20 years ago, when you talked about environmental law protection, nobody was openly talking about concrete obligations and concrete state responsibility if these obligations by states are not respected. So I think that in international law, nothing moves in a day. I know that young people, we are very impatient. We want very quick movements, but at the end of the day, states are the ones which are creating international law. That's how it is. And it's very important what messages states get at home. So public opinion in our states is very important because that will push states to move faster and to adopt things faster. But I'm very positive because if you see that over 160 states or 170 states in the UN General Assembly support certain rights, support certain developments, I think there's no way back. There's no way back and no retraction from this in the future.
Well, thank you so much. And thank you, Ambassador, for ending us on a positive note. And I'd like to thank our panel, really terrific for them to join us. So thank you so much to everyone. And thank you for participating throughout this heat wave that we're having here. I think there's coffee now and a short break. Thank you.